Hi, this is Mia. Lynn and I are gonna do the presentation of court visit today. It's unfortunate we cannot go to the court in person, but we will try our best to analyze the case and comment on it. The case we choose is HKSAR and Ng Chun Wai, which was decided in the Court of First Instance on 9th October last year. And generally, it's a case of applying for bail to the CFI. The applicant in this case is charged with possession of offensive weapons in a public place, which contravened with Section 33 of the Public Order Ordinance. What happened was there were around 100 protesters gathered outside Mongkok police station, and when the police were dispersing the protesters, the applicant was seen wearing a mask and a pair of gloves running away. So the police intercepted him and searched him. They found a glass bottle with a piece of cloth as a stopper, a half-filled bottle of lighter fluid, a hammer, a laser pointer, a hiking stick, a helmet, and other stuffs. It should be noted that at the time deciding the bail, further investigations conducted by the government laboratory and the articles found from him and his phone were not available yet. So the issue court was facing is whether the bail should be granted, and eventually the court refused the bail.
So there are some procedural issues here. We'll look at the steps the defendant can take when he has been refused bail. Let's look at the brief timeline of our case. On the 21st of September, the offense happened. On the 23rd, the applicant made his first bail application, which was refused. And on the 30th, a bail review was sought but got refused again. And on the 9th of October, the defendant applied for a review to the CFI, which is the current case here. And there are steps the defendant can take when he has been refused bail by the magistrate at his first court appearance. First, he can have his bail application reviewed on the second appearance at the magistrate's court as per Section 9G, subsection 11. In our case, it got refused again. What the defendant can do from here is that he could apply to the CFI for a review of the refusal to grant bail by the magistrates, which is our case. Section 9J CPO notes that a defendant may apply for a review of a decision of a magistrate to refuse bail or may appeal against a condition of bail to the CFI. In the CFI, the judge can order confirm, revoke, or vary the decision of the magistrate as per Section 9J, subsection 2. In our case, the review was unsuccessful, that the judge conferred the magistrate's decision to refuse bail. Let's start with the argument that the defendant has raised. To start off, there are constitutional rights that the defendant's right to liberty and presumption of innocence are protected by Article 5 of Borough and Article 28 of the Basic Law. As per Section 9G, subsection 1, the defendant is entitled to a presumed right to be granted a court bail if he can satisfy the key requirements as set out in Section 9D, subsection 2, which are the objects of bail condition, that the defendant will not fail to surrender on the required date, or commit an offense while on bail, or interfere with a witness or obstruct the court of justice. In supporting the grant of bail, the defense counsel could make an argument based on the facts such as background and previous convictions. So the background and association could be like home environment and community ties. The defendant is a local student studying and living in Hong Kong with his family. He's born and raised in Hong Kong, and he sees his future here, that he definitely has ties in Hong Kong and will not fail to surrender. Also, his parents can act as his surety as well. Also, the defendant has a clear record that he has never been convicted, i.e., he has been otherwise good character. Therefore, the defense counsel claimed that the court bail should be granted based on these arguments. And then we have to look at the arguments that the prosecution has raised. It is for the prosecution to show that the bail of the accused should be denied or subject to conditions beyond a reasonable doubt. First, the defendant's right to liberty under Borough and under the Basic Law is a qualified one, not an absolute right. The right of bail can, therefore, be refused in the circumstances set out in Section 9G of CPO. As per this section, the right to bail could be deprived if the court finds that there are substantial grounds for believing that the defendant would fail to surrender or commit an offense while on bail or interfere with a witness or obstruct the court of justice. In arguing that the defendant is likely to fail to surrender to custody as the court may appoint, the prosecution considered the nature and seriousness of the offense, which may tempt the defendant not to appear. Since the court has not granted bail to the defendant, we can conclude that the prosecution has established their arguments beyond a reasonable doubt.
So in reaching the conclusion, the court took the seriousness of the accused offense into consideration. And in reviewing the articles the applicant was alleged to have possessed, the court thought it would cause extreme serious injury and is fatal to persons, especially in the context in Northeast Hong Kong, like the recent disturbances around the streets. Another factor the court took into account is that if the applicant is convicted eventually, the heavy sentence would have a deterrent effect on him. Therefore, the court found a substantial ground for believing that there is a risk for the applicant would not appear in the court. Thus, the bail was refused.
We will comment on each section, mainly Section 9D, 9J, and 9G, and give out our own view as to the court decision. First, I'll start with Section 9D. I cannot entirely agree with the court that I think the court at least should have granted bail with conditions as per Section 9D subsection 3. Under the presumption of innocence, court-imposed bail is the legal right of the defendant as long as they promise to appear before the court on time. Balancing the public interest and the defendant's rights, the court could impose conditions of release. If the court were worried about the possibility of defendant getting tempted not to appear, the court could have imposed bail conditions such as surrender travel documents, not leaving Hong Kong, report to the police station, or reside at a specified location. My last comment is that I think the judicial crisis caused by large-scale arrest and prosecution in Hong Kong is a real concern. The society should never compromise on the rule of law, i.e. the presumption of innocence in particular.
For Section 9J, as mentioned above, this section provides when a district judge or magistrate has refused the bail or admitted the person to bail with some conditions, that person can apply for review of the decision to CFI. Based on this section, review can only happen once. However, this does not preclude CFI later granting the bail afterwards if material circumstances changed. A case to illustrate this point is HKSAR and Su Yao. The defendant in this case had applied for bail before a magistrate's court, and this apply was rejected. And then he applied review to CFI, and the review got rejected again. After that, the defendant's case was sent from the magistrate court to the CFI because this was a serious crime. The CFI judge could grant a bail, even though the review had been rejected in the past. This is because the CFI judge has the inherent jurisdiction to grant bail, irrespective of the statute. While the court's rationale in refusing the bail based on Section 9G seems unpersuasive to me. If we really look into this section, subsection 1 entitles the court to refuse the bail under 3 substantial grounds, and subsection 2 provides a list of factors the court can take into consideration in forming an opinion under subsection 1, and subsection 3 and subsection 4 listed other reasons explaining why detention in custody may be needed. And this including for purpose of further inquiry relating to determining of the question of whether the defendant should be admitted to bail. However, in determining whether a bail should be granted, the seriousness of the crime of the accused offense is only one possible consideration among all these factors. We see the behavior, the conduct, background, occupation, home environment, financial situation of the accused, or even his previous conviction record can all be relevant. So, as a lawfully entitled right, bail can only be refused within the circumstances set out in Section 9G. A case will help us is HKSAR versus Mohammed Kumsung. In this case, the prosecution had argued against the bail because the offense was serious and there was a long history of offending, and the prisoner was facing long-term imprisonment, etc. Implied by the judgment, these were not actual reasons by themselves to deny the bail. The prosecution still need to point to one of those requirements. In other words, the very fact that you committed a serious offense does not necessarily mean that you will fail to appear in the court. So, based on all we have discussed above, our group do think the refusal of bail seems harsh in this case. And this is the end of our presentation. Thanks for watching.